considered for selection in accordance with the terms and conditions contained in the advertisement unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement as his right crystallizes on the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Admittedly, the rules are not amended retrospectively, the present rules. Whether the rules have retrospective effect or not primarily depends upon the language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of advertisement. Now, this has been followed recently. This is a 2-judge decision. It's been followed recently, give copy, by a 3-judge decision in Assam Public Service Commission. This is 2020. I'm sorry, we don't.
This is also on record.
No, my lord.
It is there.
Assam Public
Serial 2.
Yes. Oh, so sorry.
Yes, she has already read it.
So it's been followed for the same, just paras 15 and 16.
Yes, she has already read that.
So it's been followed, and that's a consistent position. That date of advertisement. One small thing on facts. The date of the advertisement is 19th July 23. Now the advertisement itself gives for the last date of application 7/9/23 and last date for modification of the application is 15/9/23. Even if we were not to take the date of advertisement as when selection process commences, at least the last date
Submission of application.
last date of modified application 15 September 23. By then no amended rules had come. Impugned judgment had also not come. Impugned judgment, which is in December, becomes the basis for the January new rules coming. So there was no question really of extending a date once the date is over and done and the process is complete in my view. So even if it's not date of advertisement, even a later date, it doesn't come by then and it's not retrospective. I'm good.
Thank you.
That is all. We'll respond on those 2 points your lordship mentioned.
We'll find out. Yes, please, Mr. You are for the comment.
For the government in the first matter, not
First matter.
There is a difference in 2 matters.
the state will remain the
There
same.
is no difference is only the functioning of 2 engines.
Double engine.
Double engine. I don't know, we are trying to make ourselves the engine.
No, double we are not saying intentionally. 2 engines.
So that,
So that you can understand, we will not explain why 2
yes, my lord.
and what is the purpose.
My lord, but I must confess, my lord, my all colleague, we sat down together, my lord, to prepare a list of dates, my lord, but even with your lordship,
No consensus.
no. My lord, with your lordships, every question today, I pick up the list and see whether there is a date there or not. And I come to know, my lord, that there are 2 rules, my lord, with which your lordships are dealing. One is the recruitment rule, the other is the TET rule. So, my lord, every time with the help of, my lord, my friend and my friend here, we are finding that there are so many notifications in both the rules, which have come after filing of counter, etc., or even before that, which are not before
We
your.
are not interested in after filing of.
Only relevant, my lord, only
We are
relevant.
not interested in after filing of the counter. We are only concerned whatever is prior to that.
Only on that basis, my lord. No, my lord,
And the another question is, what is the once rule is there, already there. So where is the import of issuance of notification? Is it circular or it is an amendment in the rules?
there is an amendment in the rules.
In the rules. So prior to that, only relevant.
Lord, I
Not later.
my lord, I have to first of all answer your lordship on the question which have arisen with regard to section 23 of the Act. If your lordship, if I am able to satisfy on that answer, my lord, then most of the other questions, my lord, in my respectful submission may get answered. Kindly come to 23 straight away.
We will come to that.
Because, my lord, your lordship will just keep 2 things in mind.
RTA.
Party Act.
There is a TET rules, my lord, first of all, recruitment rules and TET rules.
Whatever you want, we will see.
Sir, I am only, my respectful submission, there are 2 rules which are applicable in the present case have some play. One is the recruitment rules, other are the TET.
No, what is to be seen first?
First of all, the act.
23.
Yes.
23.
Yes.
So you want to get out this?
No, I want to get into this with clarity, my lord, to myself. I don't want to get out.
You are clear.
We once enter the portals of the Supreme Court, we never want to get out. And we have the privilege on this side, we can choose a date of commencement or the last date. Both, my lord. Commencement as well as kindly come to 23 straight away. My lord, your lordship has seen the
And application of rules as per your choice.
which, my lord, will be decided by your lordship.
In the context you are saying.
Yes, my lord, in the context. Unless the context otherwise requires, my lord. Now, my lord, your lordship has seen the definition of school as well as the appropriate government, your lordship.
So by this time, you did 20% rule. Deviated from the thought process which have come from the petitioner side. So 20% rule you have discharged.
But with the gradually you will remind us, no?
This is situation. This is we have a sort of arguing the matter. What is life that so he said, oh, my friend saying, oh, you can't pay any money. Other side pointed out, oh, look at balance sheet. They have so much money. What are you saying? Listen, that was before the education.
Now it is plus 10%, 30%.
The rest will be played by Mr. Guru.
All right.
100% black.
23-1, my lord.
Yes.
Qualification for appointment and terms and condition of service of teachers. My lord, I'm not going into other issues which are not relevant here, my lord. Primary education, higher education, central government gets priority under entry 66, not relevant here.
That's not the issue. They have not argued it.
Yes, I'm not even raising it. This right to education 23-1 and 23-2 and 23-2, my lord, if I am right and persuading your lordship, my lord, the answer is in 23-2, which would resolve a number of issues. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. No, so far so good, no problem. Kindly come to 2, there are two extremely relevant nomenclature in 23-2 and the relaxation for that vested in the central government only Quad 2 which never improved state.
Alright, let us.
Where a state does not have adequate institution. Because, my lord, after the NCTE, it is the approval of the NCTE for all those colleges, my lord, who can legitimately and in a recognized manner grant education in the education courses like B.Ed, etc. So, NCTE approves all of them. That is the body created under the NCTE Act. They will, my lord, decide what is on what parameters a particular institution impart that education will be recognized. Where a state does not have adequate institutions offering courses or training in teacher education. Please mark it, Malad.
TET.
Two things. Offering courses or training. That is neither a course nor a training.
What is neither a course nor a
It
training?
is, I'm going to show to you.
TET you say is not a course?
Only a eligibility test like a CTET. Like a common, it's not yet exactly common entrance, the old common entrance test, Malad.
Common entrance test is different.
But that is not a qualification or training. It is neither a qualification or a training. And I will make that good, Malad, because it is provided in the rules and there is one judgment of your lordship. Let me repeat this, Malad. I wish to read it with your lordship permission again. Does not have adequate institution. So this is the legislative.
There are 3 words used.
Yes, Malad.
Adequate institutions offering courses
or training.
or training in teacher education to
Or teachers possessing unequal qualification as laid down under subsection 1 are not available in sufficient number. The central government may, if it deemed necessary by notification, relax the minimum qualification requirement for appointment teacher, but for such period not exceeding 5 years as may be specified in that
this
notification.
is one of the qualification prescribed.
One of the qualification prescribed is, my lord, their
It is the prescribed qualification or not? Then how do you say it is not a qualification?
No, Lord, the qualification and a course.
We can understand.
Malad, kindly have page 11 of the
Just,
notification.
Mr. Marinder Singh, we are not that much. We want to understand the issue. Your emphasis is where a state does not have adequate institution offering courses. One part.
In teacher education.
Please, please.
In teacher education.
Just kindly. Go separately. Where a state does not have adequate institution offering courses or training in teacher education or teachers purchasing minimum qualification as government may if it deems necessary. So this is all three adequate institutions. This is one. Here it should be a comma. It should be a comma.
Let us proceed on that basis.
Alright, it should be a comma. Then come to the point. Offering courses or training in teacher education or teachers purchasing minimum qualification. Then as laid down.
May I respond, my lord, straight away?
So this is like this. We have to read like this.
Lord, with utmost respect, there would not be a comma, my lord, with utmost humility. Why? For the reason why.
No, it is just
I'm
for
not.
understanding. Nothing, not for humanity or this is not.
I'm responding.
Not like.
My lord, I'm
For
responding.
only interaction.
Yes, for only that period, my lord, I'm responding. The state is not having something which is that education institution it does not have. Education institution is a common word both for course, that is, state does not have adequate institutions for imparting education, or offering courses in the teacher's education, that is number one. Number
It is
two,
not in the or is there before that.
I'm answering that. Now please read it again. Adequate institutions
Offering courses.
I stop here.
One,
I stop here.
yes.
And now read it again.
Not and thereafter or is there.
I'm coming to that. Just for me.
You are using and.
No, now kindly see the first. I'm only categorizing in two. What is the meaning of this?
Yes.
State does not have adequate institution is common.
Yes.
Right, my lord? Adequate institution for what purpose?
Yes.
Two different classes. One is offering courses. So state does not have adequate institutions who would offer courses in what? That courses are in the line below teacher's education. It's not the science course or a medicine course. It is teacher education.
Why the word or is used?
I'm coming to that or.
Yes, come to
Then, my lord, there are institutions who also offer training. They are not.
too far-fetched and
No, my lord, now kindly utmost respect, my lord. The does not have adequate.
you want the section to be rewritten.
No, my lord, I am not doing
Language.
I am not doing that at all. I am not doing. I am only saying, my lord, that is not a part of this particular provision. I'll show to your lordships how. If your lordship may have, my lord, it is so, my lord, because the scheme, statutory scheme is that it has also stood accepted in the rules. The 2019 TET rules specific.
All right, we take it as you are saying.
Yes, my lord.
We take as you are saying.
Correct, my lord.
Please go ahead.
Now, my lord,
Please go ahead. I will put a question then after the
yes,
question of your
now what is the sequitur of that is, if a state does not have institutions who can offer courses in the teacher education, number one, or does not possess adequate number of institutions who offer.
Your intent is offer courses or training be read conjointly. Either courses, offer courses or training, then in teacher education.
The teacher education is common.
So teacher education, what do you mean by teacher
In
education?
teacher education, there are offering courses and also for the purpose of teacher education, there is a training separately. So there are institutions who offer.
So this doesn't cover TET. You want to say this?
It doesn't fall under it.
You want to say
Yes,
this?
that's why respectful submission.
We can understand.
Let me repeat for my benefit. Let me repeat.
No, certainly.
My lord, the first thing is which your lordships have to see is the legislative acceptance that whatever scenario is existing in the country, there are states where when you lay down the NCT standard and the B.Ed courses, the adequate institution would mean those who are recognized by that centralized authority
Yeah, that is it.
to impart that course or a training. Therefore, if that is the situation, you have to meet the requirement of the state for primary education. So therefore, for a maximum period of 5 years, the relaxation for those conditions can be granted, but that authority is vested in the central government. Now my respectful submission is, my lord, if your lordship now come to, my lord, that additional document page 11 where your lordship has seen the advertisement. Just have a look at that, my lord.
No, we'll go to that. Here complete the rule.
I'm only on that. Only on that I want to take a strength from that argument. Just keep it with that, my lord. Section 23, keep it with page 11 of the additional document where your lordship has seen the advertisement. Page 10 it starts, my lord, page 10.
Yes.
This is a notification of 23rd of August 2010, my lord. I'm sorry, my lord, this is not advertisement, this is the NCT rules, my lord, of notification of 23rd of August 2010.
Describing qualification.
That is coming to page 35.
I'm coming to that, my lord, yes. Page 10. Minimum qualifications. Right, my lord?
Page
10, my lord.
10.
Minimum qualification number 1.
Yes.
Then, my lord, your lordship will see small Roman I classes from 1st to 5th.
Yes.
Now, please see the first A. Senior secondary for or its equivalent with at least 50% marks and 2-year diploma in elementary education, whatever name known. Right, my lord? This is 1. 2. Or. Senior secondary or its equivalent with at least 45% marks and 2-year diploma in elementary education, whatever name known, in accordance with the NCT recognition norm and procedure regulation. So there, my lord, your lordships appreciate, my lord, the recognition concept by the centralized authority, the regulatory authority, NCT institution that is recognized by them. Then, my lord, senior secondary for its equivalent with at least 50% marks and 4-year bachelor of elementary education, senior secondary or its equivalent with at least 50% marks and 2-year diploma in education, special education, and so or is gone. Or is the option in the educational qualification of a course. It is neither a course nor a training.
Yes, please.
It is, I'm sorry.
Yes, please. Kindly read the rule again.
Senior second, I'm starting.
Minimum qualification, class 1 to 5.
Classes 1 to 5. Senior secondary or its equivalent, that is 10 plus 2, my lord, with at least 50% marks and 2-year diploma. My lord, your lordship, know in educational, teachers for education, my lord, there are diplomas and B.Ed. Right, my lord? So one is the diploma, you must have 2 years. First of all, you have 10 plus 2 with 50%. Then you do 2-year diploma. And then, my lord, 2-year diploma. And then second choice is senior secondary, that is 10 plus 2 or its equivalent, with at least 45% marks. Supposing I have received 45% marks, I have not received 50%. And 2-year diploma in elementary in accordance with NCT recognition norm and procedure regulation. Or senior secondary, that is 12th, with at least 50% mark and 4 years of bachelor elementary education senior secondary with at least 50% marks and 2-year diploma in education, special education. And then, my lord, it or is gone and comes.
Yes.
And now permit me to read.
Yes.
My lord, 10 plus 2 is an education qualification of a course. The 2-year diploma is a course. B.Ed is a course. This is neither a course nor a training. I read it, my lord. Passing teacher eligibility test to be conducted by appropriate government in accordance with the guidelines framed by NCTE. And, my lord, now read with this, which is, my lord, otherwise the position in the 2019 rule, which is in the counter affidavit. Just keep both of these documents here. Kindly see Rule 11.
Rule 11.
Rule 11 of the 2019 rules of TET. We start at page 21. There also, my lord, we have to update. There are various amendments made.
No, Mr. Maninder Singh, we can understand whether this stand have you taken ever in the High Court? Whatever you are making here,
No, my lord, TET,
what submissions?
my lord, this is not
You
an.
can
This is not the stand taken.
But let us
You are
understand.
saying they don't have a case and you had
Mr.
to.
Maninder Singh, we can understand for the purpose of interpretation, something can be done. Alright, this is one part. But at least you must have come out with a case that please listen. So far as this qualification part is concerned, whichever you are saying, that is not required and their contention relying upon 23 would not be good because of in section 23 it doesn't specify like this.
My lord,
And even then, the government stand is like this. We can understand your argument is fine.
my lord, I have understood your lordship question. Please permit.
And you made the amendment in the rules. You also understood this all is applicable.
No, my lord.
No?
My lord,
But for the amendment was required if this is not the qualification.
3(2) is to be applied. Amendment can't be made by a state government. With utmost respect.
State only made the amendment.
Because we are entitled to amend the TET rules and our recruitment rules.
All right.
My lord, I'll answer it.
All right, all right. That also we'll see.
No, my lord,
But where is that stand in the written statement?
that's what I'm trying to answer, your
So
lordship.
you never let the High Court examine any issue?
Your lordships are questions on, my lord, state to me which must be answered, my
No,
lord.
we are asking a question. You please go by what is your stand before that.
My lord, I will
First start by that.
My lord, the prayer be relieved.
No, relieve me. Please, what is your stand before the High Court? Come with your WS. British return, counter affidavit. Please come. Mr. Maninder Singh, don't go out of that.
My lord, I will.
We not
I'll stick to
speak
the.
more than that.
My lord, I'll stick to the pleadings.
Please come to the pleading.
Yes.
Where this pleading is there.
Yes, let us see, my lord. For that, my lord, I have to show your lordship the writ petition, what is the case pleaded. Now let us see the writ petition. We have a writ petition. Show me.
Which
Page
page?
number
Which page?
268 in the SLP paper.
268.
Answer 268. Come to please, my lord, your lordship kindly come to 268.
You never argued all this. The AG conceded. That's all on his section.
My lord, I am duty bound to answer every question of your lordship.
Certainly.
The AG statement followed by the subsequent rule is a matter of record, and that
You can't say matter of record.
it's recorded in the judgment.
That's there.
Yes.
But the AG never said so. Despite the reply that they don't have a case, the AG said, all right, we'll consider them eligible.
Kindly see, the prayer is of CTET.
Yes, yes.
Inclusion of that CTET. CTET has nothing to do with 23.2. It is not claimed on the basis of 23.2.
That we have not come to that.
My lord, I'll show you
We
what is the writ.
will discuss that. Please let us understand your pleading.
I'll see the writ and the counter first. Let us go to the writ. I will try to find out, my lord, is there any foundation that you have no jurisdiction at all? The other
Case initially was not that.
my lord,
The case initially filed before the advertisement.
Yes.
It said you are not holding any test.
because my lord, there existed one is not holding the test because
Yes.
tests are not held up.
And then they said you make them eligible. That's all.
Your lordship right. 2016, after 2016, unfortunately, state has not carried any test
Whatever is
after
there.
that. The recruitment which is to take, and your lordship is absolutely right, the writ petition is filed before that. Because till that time, it is only JTET which was making the candidates eligible.
You did not have to hold any recruitments from 16 onwards.
16, nothing has happened. 16 is frozen. My lord, your lordship is right. Both, my lord, for the purpose of recruitment as well as holding of a TET.
All right.
Right, my lord? Your lordship is perfectly right, my lord. When this writ petition is filed, as per the existing rule, there is a condition of JTET to be possessed by the candidate to become eligible for any recruitment process to be held by the state for teachers. The writ petition is filed first by the candidate who are possessing CTET. They are not saying that under 23.2, CTET has to be included because that is the domain of the state. Kindly now see what is the basis of the writ petition. First, my lord, absolutely right. At page 272, the TET is not being held. Now, my lord, kindly see page 275 where reference is made to the TET of 2019. So, page my lord, 275, para 2 sub-Roman I, where my lord, with reliance on rule 12 of TET rules that you will hold the exam annually, is referred to, my lord.
2019, the rules were framed.
My lord, your lordship, which the rules which your lordship have seen in the counter page 21, they are TET rules of 2019.
Right.
In that rules, my lord, JTET is the TET where clause 12 of the rule says the state will conduct
Annually.
examination on regular basis annually. That has been referred to, my lord, in subclause Roman 1 of para 2,
Yes.
which goes up to 276 and refers to rule 12 on the top, my lord, second line, rule 12 of the aforesaid rules.
Yes.
My lord, page 276, second line on top, rule 12.
Yes.
Then, my lord, your lordship will see that sub-Roman 2, that has not been held by the respondent, particularly when there is a guideline of NCT conducting teachers eligibility test to conduct a TET in every year. That letter of the, my lord, the NCT is 11 to 11, which is relied upon. Then kindly come to, my lord, then your lordship can skip. 279 bottom Roman 6.
No debt for last 6 years.
Yes, my lord. And then, my lord, if your lordship may kindly come to the recruitment rules, which is, my lord, referred to in sub-Roman 8 at 281. Which, my lord, these rules were, my lord, just here something is relevant, which, my lord, my friend had instructed me to take that as a preliminary submission, but I said, say it but discharge its owner to answer. My lord, 2012 rules were substituted by 2022 rules. Under 2012 rules of recruitment for
There is one question. Again, same thing. They filed a writ petition, pleadings are there, whatever is there before the advertisement. You are contesting that. With reply also, with argument also. All of a sudden a stand is taken that we concede their guilt.
that's, my lord, if your
So that means pleading or no pleading, you had conceded everything.
But if the state in a given circumstances with the enabling provision and a policy, my lord, in
Not your stand.
I'm on my stand. I'm on my stand of the
You are standing, that's all right.
my stand, my lord.
Your stand is all right.
If my
But where is your stand in the reply?
I'm my lord,
Yes.
kindly, my lord, my respectful submission is this, my lord. NCTE has taken over the field to some extent. The state's autonomy to the extent which is permissible for the primary education is not taken away. NCTE, my lord, is predominance has come. Everybody must follow that, my lord, for complying the scheme.
So standards laid down.
Standard laid down, right, my lord? In that laying down the standard, the central government role for exemption or concession or relaxation is not for any norm of debt. Is not for any norm of debt. It is for the states to decide whether they are permitting CTET or not.
Please come to here.
So, my lord, if the state,
Let us understand you are coming on the pleadings of the.
my lord, clause
Then come to the
come to
WF.
81.
Then come to the pleadings of the WF.
I will.
Then come to your stand before the Supreme.
Yes, my lord, Supreme Court as well as, my lord, in the High Court to be filed to affidavit and then supplement.
We are ready to.
Yes, my lord, kindly see 281 2022 rule of recruitment. Now, what I was explaining was something important which has not been informed to your lordships. 2012 rules had not provided for any entrance test for teachers by the state. It had not provided. On your qualification, some kind of a weightage used to be given, and then you would get selected. They challenged, my lord, 2022 rules, the same set of petitioners, before the Honorable High Court, that you cannot now convert this 2012 no test to a test now, test for recruitment. They filed a writ petition stood rejected, where they challenged the 2022 rules. And the same advertisement which was put in, both the advertisement is challenged, the rules are challenged. But the High Court rejected it. 9th of September, where they wanted to rely on this petition, I am informed, I am instructed, I was not appearing. This Honorable Court has dismissed.
Suppose the rules of 52 was challenged. And
the advertisement is also challenged.
advertisement when issued?
This
July 23 advertisement.
So how it can be challenged? The rules when it was challenged.
Malad, the rule, the 23, the advertisement is issued.
There was a separate writ for that.
Yes, my lord, by the same set of petitioner.
Maybe of that hardly makes any
No,
difference.
I am so my lord, only as a
That is
man.
not making a difference.
My lord, they kindly see the prayer.
We can come to a different point.
I will, yes.
You are saying that 22 rules along with the July advertisement, it was challenged by the same set of petitioners, and the challenge was the rules. What were the rules under challenge in that?
Rule 20, rules of 2022.
What was that particular rule under challenge?
The
Petitioner.
You have mentioned so in your counter affidavit.
counter it has been mentioned.
Thank you, sir.
In Supreme Court.
That they, no.
I can assist.
The Supreme Court order.
Just no interference.
Supreme Court order is on 9th of September.
No, that's right, but did
The
you
High
mention?
Court order.
Yes. Did you mention in your counter also
What it mentioned?
that they filed this writ petition dismissed and the matter is pending before this court?
No, the High Court order, you must be aware. It's not there in the counter, my lord.
Leave aside. We want to
But it-
understand a different thing. Writ petition filed challenging the rules of 22. Which rule was under challenge? Number one,
The entire set of rules as ultra virus.
sir, entire rules can
It is there incorporated in the order.
No, we can understand what is there.
Let's have a look
But
at
then one thing,
Yes.
and the another is advertisement. Which condition of the advertisement was challenged? And
Meenakshi,
suppose
Lords, they had challenged the entire rules and the entire advertisement on this ground that because the 2012 rules are prevailing, they should get direct appointment. They should not go through this process, which is subject matter here, saying that they should get direct appointment because they have been waiting.
Also, under the present day, they will have taken an examination. So, he doesn't say examination.
And interview.
After 22 groups, they have taken examinations for appointed. They wanted to overreach the 22 groups to say that it was
what is the relevance of that even? Maybe that as per rules. At present, 22 rules are in vogue. 22 rules, as per 22 rules, whatever is read over, for the purpose of qualification, for the purpose of entrance test, it is not in dispute. So once it is not in dispute, then even they have challenge for that, and whatever the decision is dismissing that petition, what may be a consequence to the present point? There may not be consequence of present point. And see, we'll look into let Mr. What is the relevance of this, Mr. Maninder? Mr. Maninder Singh, please.
kindly see, my lord, page 281, I was showing to your lordship the two reference.
Yes, please.
For reference to 2022, then, my lord, your lordship may kindly come.
Yes.
Para 8, my lord, that the state is not conducting TET after 2016.
All right.
And then, my lord, if your lordships may, in continuation of that, kindly see para 7, 286. 286 para 7. It is relevant to state and submit that the petition number 2 is the mother of one of the aspirant who is willing to participate in the selection process in the state but cannot do so because of the mandatory requirement of JTET qualification, whose examination has not been conducted since 16. The petitioner too has come across several number of candidates who possess all the requisite qualification to be a part of selection process, but the state has made JTET as mandatory. It is not being conducted state for last 7 years. And then, my lord, if your lordship may kindly come to the prayer. Page 289.
Page 289.
Last 3 lines, my lord, prayer A. For showing cause respondents, teachers eligibility test examination, the state since the year 2016, in spite of regular demand and protests of large number of affected candidates, which is not only creating chaotic situation, the law and order, but also amounting to ruining the aspirations of poor students who are merely aspiring to participate in the process of appointment for the post of teachers. which very much requires a candidate qualified TET as mandated under the provision of the National Council for Teachers Education guideline, as per which such examinations to be conducted on yearly basis. But unfortunately, no compliance by the state respondent, gross violation of the guideline of NCTE and the rules of 2019, which are the TET rules, where also the stipulation is contained that you will conduct it regularly.
But if we read this in true sense and spirit,
Yes,
then these petitioners has stated that as per NCTE, under RTE, NCTE is the authority which shall prescribe minimum qualifications for the purpose. They admit this part. TET is mandated under the provisions of the National Council of the Teachers Education guideline, as per which such examination is to be conducted on yearly basis. Like this part they are admitting for the purpose of examination, because this relief relates to that holding of that examination. Now come to B.
for showing causes as to how they will address the aspiration of large number of candidates available in the state of Jharkhand who have acquired all other requisite qualifications for participating in the process of recruitment of teachers in the state other than having the mandated TET qualification only because of fault and laches on the part of the respondent who have neither conducted the TET examination since 2016 nor have they taken a decision to recognize CTET qualification.
So here they say recognize CTET. Now come to next.
For directing the respondent to either conduct the teacher's eligibility test in the light of the Jharkhand Teachers Eligibility Test Examination Rule published, notification number so and so, which mandates the state authority to conduct the TET examination every year and oblique or to consider the CTET qualified candidate worthy for participating in the selection process of the teachers in the state as per the policy of 2011. Now, my lord, this, if your lordship may kindly see, there is no argument of any 23(2). The only argument is that the NCT prescribes.
What they are asking there before the writ court, they are asking that we are aware CTET is not the qualification prescribed for the teachers test in the JTET in the rules of 22. So please, number one, hold the regular test as per 2019 rules. Number two, or CTET may be
Included for eligibility.
included for eligibility.
Correct, my lord.
Now for that purpose we have to look into what is the answer of the state.
Surely, my lord. But what I am yes, my lord, your lordship may kindly come to the counter 295.
Yes, please. Please, where we have to look into?
My lord, 295 it starts.
Yes, please.
Kindly come to 297 bottom para 7. Where, my lord,
You have taken it as a public interest litigation. So you said it is an instant public interest litigation was filed for the following reliefs.
yes,
Alright, then you have referred to the reliefs.
yes, my lord.
Then you have started answering so and so. That is stated as submitted without para-wise reply.
301, my lord.
Yes.
1. Kindly see para 10.
No, first 9. You recognize RTE Act.
No, but that RTI nobody can run away. I know that the
We are only referring, Mr. Maninder Singh. They are not saying
yes,
anything.
the RTI Act is
Say what appointment of a teacher in any of the school referred in clause N
Yes.
of section 2 of RTE Act
my lord.
is he or she should possess a teacher's eligibility test
Yes.
which will be conducted by appropriate government in accordance with the guidelines framed by NCTE.
So that is
So for the answer one part, this is next.
and
Come to 10.
it is stated that therefore the respondent is serious in implementing the provision of RTI in its true spirit and letter, for which various consultations carried out by the respondent with different stakeholders. Better implementation of TET objective after looking to geographical and regional needs and requirements such as various languages, tribal cultures, Hindi language speaking, population difficulty before conducting a fresh CTET examination in the state of Jharkhand.
Yes.
Para 11, that the COVID-19, my lord, your lordships can skip.
All right.
12. So far CET exam is concerned, center teacher eligibility test is conducted for determining the eligibility of the candidate for post of 1 to 8 in central government schools such as NBS, KBS and other schools which does not fulfill the needs and requirement of the state, regional languages and other local needs, and whether to consider CET qualification as equivalent to JTET in the matter of policy decision. Then, my lord, your lordship, you can come to para 15.
Yes.
Respondent in the process to bring necessary amendments in the JTET exam to bring it on the quality and standard of CTET level. It's most humbly submitted that the respondents are going to bring some necessary amendments in the JTET rules which is under
Rule kindly para 13 is also given.
Yes, not 13 I read.
It is most humbly and respectfully submitted.
Respondent said it is in the process of framing a rules for conducting fresh TET examination in the state of Jharkhand which is under process and due to which much time has passed for conducting TET examination in the state of Jharkhand. Then my lord, 14, once the rules will be framed, it will be sent for cabinet.
Then 15.
15, the respondent in the process to bring some necessary amendments in the JTET to bring it on the quality of CET test. And my lord, it's most humbly and submitted that the respondent are going to bring some necessary amendments which are under process. Stated that the circumstances prayers are misconceived. So, my lord, what the state response?
It's only TET, about TET you are telling.
Only about TET because the prayer is only for TET. Conduct of TET or CET be permitted.
Eligibility.
All right.
It's a eligibility test.
All right. Please go ahead.
My lord, then
And one thing you admit here, there are 15.
yes.
The respondent is under process to bring some necessary amendments in JTET exam to bring it on quality and standard of CTET. That shows that your standard is lower.
What happens is,
This is what you are saying.
Lord, the standard of CTET for central schools and other schools
Is higher.
does not necessarily mean, my lord, the standard in the state may be lower. But yes,
This is what you are saying.
it's always an aspiration, my lord, that you must also be in that my lord, pedestal where you say, I am as good as anybody else. But that does not mean, my lord, that I am not meeting the requirement of minimum.
That you have to accept that somebody is above.
Your stand is, it indicates that further respondent is under process. Necessary amendment in JTET exam
Yes, my lord.
to bring it
Yes, my lord.
on the quality and standard of CTET level.
Correct, my lord.
What does it mean?
My lord,
Your exam and the rules are not at par to the CTET, so you want to protect to the CTET
the
level.
lordship may also read it with para 12, my lord.
Yes.
Read.
12 if your lordship may permit.
Yes, read.
That so far as CET exam is concerned, CET test is conducted for determining the eligibility for teachers of classes 1 to 8 in the central government schools such as so and other schools etc. which does not fulfill the needs and requirements of state, regional, language and other local needs and whether to consider CET qualification as equivalent to TET in the matter of policy decision, which followed is the clause 10 of NCTE. And clause 10 made it only enabling for...
Please go ahead. This is not a clause. Go ahead.
Clause 10, I have to come...
We'll consider, we will not look into on that. Come, go ahead.
Yes, my lord. So this is the reply which is given, my lord.
No, please go further.
Yes.
Further reply.
Para 16,
Yes.
it is submitted that the respondents are going to bring some necessary amendments in the JTET rule which is under process.
So, this is, you said, this is misconceived. Then rejoin the affidavit. Third here, anything about that point that the CTET must be made applicable or not? You said merely said one line, it's a policy decision.
No, I am saying something else, my lord.
So this is the first counter affidavit.
Yes, my lord. Of
Which
course.
is another counter affidavit.
Yes, my lord. Let me show the second counter and then make my submission.
Yes, please.
Supplementary affidavit. 300 and my lord 15.
315, supplementary counter affidavit.
Yes. It starts at my lord 314. And then my lord, your lordship may kindly see para 5 at 317.
No, there is some order of the court.
There was an order of 15, 745, 7.
The petitions were
Which is that order?
25-7 order.
Import of that also.
25-7 order. Just that is one Lord, your lordship seen yesterday that the rate petitions were filed before the advent.
No, that's right.
You want to see this order of 25-7?
Yes, yes, I'll just give it to your lordship, Lord, that order.
Where is this order? Page 58 of
The counter affidavit.
Supreme Court counter affidavit. Supreme Court counter affidavit दीजिए. Supreme Court का counter affidavit.
It's page 15, 15. 58, my lord, I'm sorry, page 58. Same, my lord, where your lordship has seen that rules. Same volume. In the course of hearing, at page 58, my lord, if your lordships have got it.
Yes.
In course of hearing, learned senior counsel, she is so and so appearing for the petitioner in the lead case, would draw the attention of court to clause 10 of the guideline for conducting TET, which is provided at subclause 2. I'm sorry, my lord, your lordship, this is my opinion. I read it.
Yes, please.
In course of hearing, learned senior counsel appearing for the petition, the lead case would draw the attention of the court to clause 10 of the guidelines for conducting TET, wherein it is provided at subclause B that a school referred to in subclause 1 and subclause 2 mentioned therein may also consider eligibility of a candidate who has obtained TET certificate awarded by another state duty with the legislature in case a state government duty with legislature decides not to conduct a TET school at 1 and 2 in the state duty would consider the TET conducted by the central government. We are of the opinion the state government is genuinely creating a number of posts for the state TET examination required to be conducted, which has not been held at least for last 9 years. The examination was held in 16. Then it should take into consideration the said provision. We advise the state to file a short affidavit stating whether they intend to allow these candidates who have obtained TET certificate from the central government.
Now read your counter.
Yes, Lord. Now kindly see, come to para 5, 317. 317, para 5.
Yes, please.
The reference is made to this order, my lord. So your lordship can skip para 5, para 6. It is submitted that before going into the query, it is necessary to bring a factual aspect for proper adjudication. One of the essential qualification of person to be appointed teacher is referred to in so and so is RT Act is that he should pass the eligibility test of TET, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. It is stated and submitted that state of Jharkhand is intending to implement the Jharkhand TET objective in consonance of the geographical, same thing, Lord, with regional needs requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. It is most humbly submitted that the central teacher eligibility test hereafter referred to is basically concerned is conducted for determining the eligibility of candidate for teacher post class 1 to 8 in the central government school such as NVS and KVS and other schools. It is stated that the state of Jharkhand has formulated its own teachers eligibility test rules of 2019 dated 4/10/19, which apart from math, science, social study teacher stipulation for language teacher, the rules further prescribe for eligibility of teachers imparting education of regional language, other local tribal languages for the preservation of culture, needs and diversities of the state. It is stated that Jharkhand Teachers Eligibility Test Rule 19 prescribe for different eligibility criteria with respect to appointment of language teachers who are required to have qualification, at least one local language out of various local and tribal languages spoken in the state. That also, my lord, would answer your lordship. One, either the regional or tribal, my lord.
That the rules provide.
Yes, that is stated that Jharkhand Council of Education Research and Training, Ranchi, is responsible for performing the important function of promotion of education research, improvement of education technique, practices and search finding development. Curriculum is in instructional and exemplar material method of teaching techniques of evaluation teaching data. It is stated that the Jharkhand Council of Education Research and Training, apart from aforesaid activities, publish and distribute books for regional and tribal languages free of cost, etc. further stated that there are enough numbers of JTET qualified candidates within the state and hence allowing CTET qualified teachers in the vacancies of the state and school with cause prejudice. Stated that there can be no doubt about the fact that the ultimate beneficiary of the recruitment process would be a large number of children within the state who would suffer if there is undue delay in the appointment of teachers. However, the state is at liberty to set the qualification, particularly when these qualifications are in accordance with the statutory guidelines framed by NCT. Please mark this sentence, my lord, that it would be for the state to decide which, my lord, test is to be permitted, because that is the domain of the state, and that is also, my lord, recognized and acknowledged in the NCT guidelines. It is further stated that petitions contend and place reliance on clause 10B of the guideline for conducting teachers eligibility test, which provides that TET conducted by state government with legislature shall apply to a school.
To complete this, there will be.
Yes. School of the state government duty with legislature and local authority referred to in subclause 1 of clause N of section 2 and a school referred to in subclause 1 of clause N of section 2 of RTL. The guidelines further provide that a school at 1 or 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state utility with legislature. In case a state utility with legislature decide not to conduct a test, a school at 1 and 2 in the state UT would consider a TET conducted by the state government. That it is further stated central TET qualified candidate qualifying TET by another state can only be considered for a state-run school when the particular state government has decided not to conduct its own test. Submitted that it's not the case of the state government has decided not to conduct the JTET, and these circumstances state government is not bound to consider central TET or a candidate qualifying TET by another state UT as eligible qualification. The CT qualified candidate can be made eligible in a given contingency where the state government is not conducting TET, but when the contingency does not exist, there is no occasion to make central TET candidate eligible or to allow those candidates who obtain TET certificate from central government or any other state. This is submitted that there have been certain contingencies due to which regular JT examination could not be conducted regularly, and hence the state is intending to allow age relaxation to the candidate for upcoming vacancies. Moreover, it is also intended to conduct JET examination before start of fresh recruitment of teachers within the state. Stated that issue whether to consider CET or TET from is a matter of policy decision of the state government. I have read and understood, so that is.
But before this date, the advertisement had been issued.
Before this date of filing this affidavit. This
is 14th August.
14th of August.
July advertisement was there.
Advertisement is issued on 9th of July.
July.
Yes, your lordship is right. I'll come.
Will come back. Feedback.
Yes.